much appreciated. We've read the briefs and we've conferenced the case. And with that, let's begin. I guess, is it Mr. Say first?
AC, Your Honor, yes.
AC, I'm sorry. Mr.
No
AC, please proceed.
All right. May it please the court, counsel, my name is Glenn AC. I represent the appellant, the Yavapai County Attorney's Office. In this particular case, as you're aware, in looking at the briefing, the state had appealed or asked this court to review the hearing of the Superior Court, or the decision of the Superior Court in this case. And in looking at this, the state had initially argued it as a post-indictment delay case, and whether or not it was a post-indictment delay case, whether or not the court correctly found that there was indeed post-indictment delay. And then the state, upon the further briefing that was asked by the court, kind of changed course somewhat, in that we found this Medina case, which the state alluded to in its second set of briefing, regarding the facts in this case. And the reason that the state feels that's significant is because the facts in the Medina case are substantially similar to the facts in this case. And so the state's argument today is an argument that this case was in fact not a case of post-indictment delay, but it was in fact a pre-indictment delay question that should be analyzed as such. Essentially, in the Medina case, the reason that it's substantially similar, in that case the defendant was arrested in 1993, and released on a bail, was indicted in 1994, and then he wasn't arrested on that warrant until 1996. However, this court held that the appeals court held that this case was that the time had not started accruing for purposes of the U.S. Constitution, the Arizona Constitution, or Rule 8.2 until, in fact, the defendant was held to answer for that charge. So, in looking at that, the time, it's the state's position that the time should not be calculated until the defendant is held to answer, which in this case wouldn't have been until Ms. Fulton was arraigned in September of 2018. So, given that this, in the state's argument that this should be a pre-indictment delay case, the state feels that the Marion analysis is important in this case. So the question then becomes whether or not whether or not it was a willful delay, and whether or not it was done deliberately for the purposes of some type of tactical advantage. The appellee has argued that the delay was willful and deliberate because after the indictment was filed, the state didn't make any further demonstrable effort to locate Ms. Fulton. However, the state, as indicated in the facts in this case, makes the argument that the behavior of the defendant during the investigation of the case kind of dictated the behavior of the state. And this is not to say that the defendant has any kind of obligation to bring herself to trial. She doesn't. That's clearly established. However, in looking at this case, the state would submit that it was a deliberate avoidance of contact with law enforcement, and the idea that she was unaware of any kind of case or anything like that going on is simply not true if you look at the facts. Given the fact that she was contacted numerous times in numerous different ways, there was actually an appointment set up by the investigating officer, which was then had to be rescheduled for unforeseen reasons. Several voicemails were left, several times cards were left on the door at her residence that, by her own admission, she has lived at for a number of years, same phone number for a number of years. So in looking at that, the state feels or submits that this was a deliberate effort, and that dictated the law enforcement's further response after the indictment was indeed filed.
Counsel, let me interrupt you. Let's assume, just for sake of argument, that I agree with you that this is not a case of post-indictment delay, or at least wasn't analyzed properly below as a case of post-indictment delay, and we're talking pre-indictment delay here. Why do I let you make that argument now? You didn't make it to the court below, and you didn't make it in your opening brief.
Your Honor, I think that in looking at the briefing, that the further briefing that the court asked, I think it's relevant. When you look at the Medina case and the fact that it deals specifically with those questions that were asked on the further briefing,
Right, but I get that, but why do we let you make that argument now or rely on that argument now? Generally, our court, not generally, at times our court, depending on the circumstances, says that if you don't raise an issue below, you've waived it. And you were presented with a motion from the defense counsel who said, look at this post-indictment delay, and you responded, the post-indictment delay wasn't too bad. You didn't respond until the trial court, no, this isn't post-indictment delay, this is pre-indictment delay. And then you file a appellate brief that says, opening brief says, this doesn't make that argument either. And we often, on cases where defense especially fails to raise an issue in their opening brief, we consider it waived and don't let them raise it in their reply brief. So why should we treat this any differently?
Your Honor, and I think it's because the analysis in this case, it's important to the analysis in this case about whether or not it is pre or post indictment delay. I think that the court.
No, I agree with you. It is the dispositive issue in this case. But why don't you tell me why or explain how your office missed it so badly, both at the trial court level and at our level?
Your Honor, our office was simply responding to the brief of the defendant and responded by stating essentially the same argument, but just that it wasn't post-indictment delay either. That the prejudice presented to the defendant was not significant, and there wasn't actually any actual prejudice claimed or demonstrated for that matter. And the state and that the court still found that analysis wrong in either case. But the state is still making the argument that the analysis by the court was wrong, whether it's post-indictment or pre-indictment delay.
Counsel, could you address what you understand the burden to be, the defendant's burden, I guess, on the pre-indictment delay, and why she hasn't met that burden?
If it is pre-indictment delay, Your Honor, the burden is they do have to show the actual prejudice. If any of the delay can be attributed to the defendant in any way. And so the state's argument would be that it can be attributed to the defendant in a significant way, given her behavior while the investigation was going on, which dictated the behavior of the law enforcement after they got the indictment by not further pursuing or attempting to enforce that warrant.
So just to be clear, your argument is that during the investigation, because the defendant didn't sort of actively seek to be investigated and assist the police, which under our Constitution, defendants have a right not to do. They actually have a right to remain silent or to and so forth. So you're saying because she, in effect, exercised that constitutional right by not helping the police do their job of the investigation, she should be held to account for their continued delay in just apparently deciding not to exercise or follow through on the arrest warrant?
No, Your Honor, and I apologize.
So talk to me a little bit about what you're saying was her fault here, as opposed to law enforcement's decision-making in how to investigate the case, and why does that apply to the period of time after the arrest warrant was issued, but no one attempted to serve it?
Sure, and I understand it's very confusing and it's a very fine line, but what the state is saying is that certainly it's not her obligation to speak to law enforcement, but the claim is that made by appellee is that she's lived at the same residence, she's worked at the same place, she has the same address, they could have contacted her at any time. And the state's argument is, well, they did try to contact her many times, and she avoided that contact. So for that reason, that's why the state simply put the warrant out there and let it take its normal course, like is often done in a lot of different cases, because at that point, the state's impression was that she was evading contact with law enforcement, so they were just going to allow the warrant to take its normal course and to be picked up on the warrant for any other variety of different ways. So the state's not making the argument that she had the obligation by any means to bring herself to trial. Essentially, the state is simply making the argument that her behavior dictated the response that law enforcement made as far as obtaining an indictment rather than a summons, and also just allowing the warrant to take its normal course and to be picked up when she was picked up for any other minor traffic violation or something like that.
So it's the normal course in Yavapai County to issue arrest warrants, but for law enforcement not to serve them? That's what you would describe as the normal course?
No, Your Honor. Very often they are able to serve them, but the state would submit that in this case, given the fact that they had attempted to contact her numerous times, at that point the state felt that just issuing the warrant was the appropriate matter. They didn't want the case to kind of drag on any longer.
And so what element of the pre-indictment delay analysis does this go to?
Well, this goes to showing that there has to be at least some fault, Your Honor. If any fault, under that analysis, if there is any fault shown to the defendant, then they have to prove that there was actual prejudice.
So the fault on the part of the defendant related to the arrest warrant is her conduct not related to the warrant, but related to the investigation. Do I understand that correctly?
The fault is that her behavior dictated what law enforcement's response was. They at that point had made numerous attempts to contact her to try and pursue this case.
How many is numerous?
I think documented there are 6 contacts, but
over the course of how long?
Over the course of let's see, it happened in 2013. And the warrant was obtained. The last contact attempted was in February of 2015, and the warrant was then obtained in October of 2015.
So between 2013 and the end of 2015, there were 6 attempts to contact her.
6 documented, six
but
documented
none after
attempts.
that.
6 documented attempts. There may have been a few more. Those are just the ones that the investigator actually documented.
Okay.
So if the analysis, again, under the pre-indictment delay, if you can attribute any fault to the defendant, she has to show actual prejudice. And in the state's mind, there hasn't been any actual prejudice shown. There's been claims that there may be prejudice, or that, and the simple prejudice is, the standard is whether or not maybe the defendant can't remember, or a witness can't remember, or evidence is no longer available, etc. And the state would note that all of this, that again, this is pure speculation. This is not actual prejudice shown. Even by the defendant's own admission, she indicated in her brief that the extent to which these claims may affect her defense are unknown. But the state would note that all these are very heavy, paper-heavy type of cases. These financial type of cases. All of that information was gathered in the beginning. All of that information has been provided in disclosure. It's all been made available. And simply put, allowing a defendant to state, well, now I don't remember, and using that as a precedent to allow a case to be dismissed is a bad precedent, because every defendant would just then be able to just hold out long enough that they can say, well, I don't remember, or this witness doesn't remember. So if that's the precedent that we're setting, then it's a precedent that is it's a bad precedent to set. So basically, since there hasn't been any actual prejudice shown or demonstrated, the state would argue that given that this is a pre-indictment delay, or this should be analyzed as pre-indictment delay, the state would submit that looking at those the facts in the Medina case, where the defendant, the court held that the actions of the state were sufficient, and the state at this point would note that in Medina there was no evidence that the defendant tried to evade apprehension. But there was evidence that the state made simply one attempt to contact the defendant and took no further action. The court even noted in their opinion that the defendant's current address was registered with the Motor Vehicle Department, and the state didn't bother to look it up. But the court still held that this was a case of pre-indictment delay, and that the delay could not be attributed until she was actually held to answer for the charge, which would have been at the arraignment in this case. So if there are no further questions from the court, the state would like to reserve the remainder of its time in rebuttal.
Okay, well, thank you, Mr. Asay. And now let's go to Mr. Mendoza.
Thank you, Your Honor. Just briefly, I cannot see the timer on my computer anymore. I saw it earlier when we went to get the other judge on the line, it disappeared. My computer just is loading and it's spinning, so I can't see the official timer. I'm just going to, I guess, keep my own timer over here. Okay.
So here, yeah, I want either that or I can keep one on my phone here.
I'll keep it on my phone over here on my end, so I kind of know how much
Okay.
time I have. I'm
All
sorry.
right.
I just can't see.
We'll run ours as well. But
Okay.
yeah, that's a good idea.
Thank you. You may please the court. Mark Mendoza, Your Honors, on behalf of Cindy Fulton, who is the penalty in this particular case situation before the court.
I can't hear.
Mr. Mendoza, you're breaking up.
It's like a bad
You cannot hear me?
connection.
Now we can.
connection-
Why don't you start
Yeah.
over and go from now?
Okay. Yeah, you guys disappeared on me. I can't see you anymore. But if you can hear me, may it please the court, Mark Mendoza on behalf of Cindy Fulton. I can see the timer now. Your Honors, as the court is aware, Ms. Fulton is accused of offenses that occurred back in, allegedly beginning back in 2012, I guess, ending in presumably 2013, when law enforcement was notified of a complaint against her. Law enforcement began to attempt to contact her in late 2013 and did not issue their complaint against her until October of 2015, nearly or over 2 years later from when they first began investigating her. It was then almost a couple of years later, it wasn't until April of 2018 when she was arrested in Colorado, which is the first time she had learned about there was a case, in fact, against her in the Yavapai Superior Court. I just wanted to check. Can everyone hear me okay?
I can.
Yeah.
Okay.
There's a buffer every paragraph or so, but
Oh, shoot.
I've heard everything so far.
Okay. I'm sorry.
Let's stop. Can we put like a little bit more time on the clock for that? All right. Well, just go ahead.
Okay. As Your Honors is aware, she was not made aware of anything in this case until April of 2018, which was nearly at that point 5 or 6 years after the fact. The state is indicating this case is a paper-heavy case because it involves bank records, but that's not all this case is relying on. It's relying on people's memories about what happened. It involves her being a treasurer for a booster club of a gymnastics group, and what the state's accusing her of is misappropriating funds, essentially. This is relying on her remembering transactions, multiple minor transactions from, at this point now, much longer ago. What did she spend money on and what did she do with that? Bank records are one thing to show that she may have taken checks from the booster club and put them into her account. It's another thing for her to be able to explain what was that for. Was that reimbursing her for something or not? She had a number of issues we have with the delay in this particular case. Is there was a delay in the investigation. It took some time, but then the state did decide the investigation was complete, I guess, at the beginning of October 2015 when they issued a complaint and then sought and obtained a warrant for Ms. Fulton.
Mr. Mendoza, you've been provided with the discovery of what amounts they allege were stolen and which transactions are at issue. Is that right?
Yes, I have, Your Honor.
Okay. Generally, to show prejudice, you would have to show specifics. As I read your briefing, you're just alleging kind of a generic or generalized potential that there might be memory issues. Are there any specific transactions, charges, et cetera, that you can point us to show specific prejudice on your ability to defend your client?
Your Honor, I'm so sorry, but there was a huge delay in the middle of your question. I didn't hear the second half of it. I am sorry.
It's okay. And, you know, we're all still trying to work through this, so I appreciate you letting me know.
Yeah.
Are there specific facts, issues, transactions, deposits, withdrawals, etc., that you can point us to show prejudice in this case, as opposed to just general, well, my client may not remember some of these transactions?
Your Honor, we did not, at the lower court level, we did not get into that. My client was there and could have testified to those things. But the fact of the matter is she doesn't have a memory of any of the specific transactions that the state's alleging are inappropriate use of funds. And obviously, as time has gone on, and now years and years, she
All right, now I can't hear you, Mr. Mendoza.
doesn't have a record of those to be able to defend herself and say, can you hear me now?
Yes,
Yes.
I can, but I think we missed the last 10 seconds.
Okay, I don't know if moving my computer around helps or doesn't. I'm sorry about that. She just generally has no memory of the events. For example, she would, again, this isn't part of the record. This is something that wasn't asked for by the lower court, but that, you know, she doesn't have any specific memories, but she would, for example, use her personal funds to buy things for a fundraiser, and then take monies from the gymnastics booster club and reimburse herself. So to a lay observer, it was like she's taking money from the booster club when that may have been a reimbursement for some purchase in the past, but that's all relying on specific memories because the state is pointing to specific things, saying these are illegal things that she did. That requires her not just, it's not just a matter of looking at records, because yes, you could show money went from booster club counter or somewhere else, but it's what was going on during that is really the crux of this, and we can't defend against it when you're talking about the delay that's involved that I believe is attributable to the state, which is the issue here is the delay, you know, pre the complaint and then post the complaint as well, more specifically.
Do you acknowledge, Mr. Mendoza, that this is a case of, at least what you're alleging is actually pre-indictment delay as opposed to post-indictment delay?
Your Honor, yes, there was not an actual indictment that occurred until much later after she was arrested. However, in this case, as the court is aware, the state chose at some point, the case was submitted to the state in, I believe, 2014. The state, the Yavapai County Attorney asked the police to document their attempts to contact her, which apparently they did. And then in October of 2015, the state chose to do a complaint and requested a warrant at that point. Technically, she was not indicted at that time, but Your Honor, this is very much analogous to an indictment because then they did nothing on it and sat on it for years and years and years until she just happened to be arrested. They talk about the normal course of how warrants play out, but this isn't the normal course. This is distinguishable from Medina, for example, when that individual had moved, change addresses. Now she lived at the exact same address the entire time. They knew where she worked. They did nothing and sat on it. And then once she's arrested, at that point, choose to go indict her and say, aha, you know, talking about pre-indictment delay. It seems as though they intentionally wait and then want to use that to gain an advantage here in the diminishing of memories and specific recollections of things. They don't get to have it both ways when they're attributable for the delay in the case. Can everyone still hear me okay? My timer keeps jumping and speeding along. That tells me there's
There was a
some bit of
little bit of distortion, but I was able to make out everything you said, Mr. Mendoza. I don't know the other.
Oh, okay.
Yes, please.
The issue here. I'm sorry, Your Honor.
No, I was just saying, please continue.
Okay. The issue here is the fact that the delay is attributable to the government. That it was essentially very long, and the government is more to blame for the delay than the defendant. That the fact that Ms. Fulton didn't allegedly call police back or didn't agree to meet with them anymore or anything else, that's not. That's her exercising her rights, as Your Honor had already pointed out. That can't be a cause for the delay. The issue is that they decide and then sit on it and do nothing on it for years and years and years. Meanwhile, her memories as to the specific transactions is gone, and there's nothing that she can do about that. They did nothing. We questioned the witness, the case agent, about this. He said he was aware a few weeks after the warrant was issued on October 5th, I think October 22nd, 2015. He was aware. He was a little surprised by that because he had requested a summons. But then he did nothing. He left his employment there, and then the law enforcement did nothing that's ever been documented since that point to contact her. Any attempted documentation of her complaint in October of 2015, they did nothing. There's no documentation of contacts with her after that. And I think this is distinguishable from Medina, because in Medina, that individual had moved and then tried to claim, hey, I didn't know about this. This is, Ms. Fulton lived at the exact same address and location. No summons ever went out to her. She was never aware this was going on for another couple years until she was arrested, when this case was already kind of old to begin with, the investigation portion of the case.
Counsel?
And so I believe that, yes.
What do you make of the, I'd like to hear a specific response to the state's argument that the defendant's conduct during the course of the investigation makes the delay attributable, at least in some part, to her, because law enforcement, that course of conduct suggested that going to her home or going to her business would not be a fruitful exercise. What's your response to the state's argument in that regard?
Yes, Your Honor. They, in order to understand that, you have to get into the specifics of the 13. That's when they, in November of 2013, when the detective first calls my client to set up a meeting. A meeting is set up in December of 2013. The detective has to cancel that meeting for, I believe, personal reasons. And then in June, first hear of the complaint about the case, she's no longer in contact with them. They can attempt to contact.
Mr. Mendoza,
I'm sorry, you cut out again.
But she's exercising her right to not talk to them at all. Yes.
You cut out there. If you could repeat yourself.
Yes. The investigation began in the fall of 2013. In December of 2013, Ms. Fulton police had to cancel that.
Mr. Mendoza?
And then no more contact was had with
Mr. Mendoza, we're losing you. It's like a bad connection.
Directly, although they did go to her work.
If you could read, are you using your phone, Mr. Mendoza?
They confirmed. Yes.
Maybe move to someplace where you're getting a better signal, because we've not heard anything you've said for the last 45 seconds.
Office.
I don't know. Is it hardwired or are you using
Just move it
Wi-Fi?
to my office, perhaps. No, I'm using a Wi-Fi. Can,
Yeah.
can you hear me any better now?
No.
It's just a bad connection.
Can you hear me at all now?
Yes.
We can hear you, but it's still kind of freezing and stopping and starting.
Although that last sentence was clear.
Can I try to log back in on a different computer briefly? Would that be okay?
Yes,
That's fine.
that's fine.
Let me.
How much time's on the clock?
7 minutes and 31 seconds.
Can I log in on a different computer briefly and try
Sure.
that?
Yeah. Why don't you try that? Preferably one that's hardwired to the internet if you have such a thing.
Okay, let me try to log in on a different computer really quickly. Okay, I think I'm logged in on my other computer.
You need to disconnect the first one.
I am. Okay. I'm sorry. Can you hear me okay?
Yeah, but you haven't disconnected the
Yeah.
first one still.
I am. Let me try this again. Can you hear me okay?
Yes, we can hear you, but you still are logged in on both computers.
Oh, jeez. I logged out. I closed out of the other one. I don't even have it up on my computer anymore. It still shows I'm logged in on the other one.
Yeah, but we're not getting the feedback anymore, so maybe it's okay now.
I'm so sorry, Your Honors. Can everyone hear me okay?
Yes,
Much better.
Okay, I'm sorry about that. Oh. As to the last question, as to what would may be attributable to her and the delay in the investigation, the delay in the investigation, I agree that police have the liberty to take as long as they need to conduct their investigation to some degree without unnecessary delay. And I understand cases that are heavy in paper and bank records take some time to investigate. The investigation by police began in the fall of 2013. They had an interview set up with her in December of 2013. The police had called Ms. Fulton and canceled that interview because I think the detective had a personal matter he had to attend to. Then he attempted to reach back out to her in January, and that's presumably when she no longer contacted them back or they had any more contact with her. They made other attempts in early 2014 to contact her. They got bank records in 2014, and then in 2015, the county attorney's office asked the detective to document his attempts to contact Ms. Fulton more. Presumably at that time he attempted to contact her again in 2015, and then in October of 2015 they did their complaint. All of that delay, if you want to call it that, during the investigation portion, again, police can take as long as they need in their investigation. She has no obligation to participate in that. That can't be attributed against her in any way, shape, or form. If she's exercising her rights and doesn't call them, even though they know where she lives, they know where she works, she didn't move, they had all that information, it should have been obvious to police, and apparently at some point it became, that she was not going to speak with them, and then they choose what they want to do at that point with their case. The problem becomes in October 2015, they decide to do a complaint rather than an indictment and then get a warrant for her arrest, but then presumably do nothing with that warrant. And then you have the delay until 2018 when she's arrested. And that's the issue we have is once they decide to do a complaint against her, they then do nothing. And that's not attributable to her in any way, shape, or form. None of it is. They knew where she was, and they did nothing to find her, to contact her, to begin that case, to notify her complaint had been filed. Instead, what they did is choose the complaint. They then get a warrant, and they sit there and do nothing. There's no documented attempts to contact her, to execute that warrant or anything from October 2015 on. And then now, when she's arrested, now they choose to indict her. And quite honestly, that could be considered the tactical advantage that the state gains, is by doing nothing, by sitting on their hands prior to that indictment. And memories, specific memories, and we're talking about specific instances of conduct, specific transactions that she's supposed to remember now from presumably 6 years prior. That
Counsel, if I could interrupt you for a second.
Yes.
As I read the case law, I'm specifically looking at State v. Broughton. It says that to establish pre-indictment delay that has denied a defendant due process, there must be a showing that the prosecution, and I'll break it up here, intentionally delayed proceedings to gain a tactical advantage over the defendant, or to harass him, and that the defendant has been actually prejudiced by the delay. I understand your argument regarding prejudice. What is your evidence to show that they intentionally delayed proceedings to gain a tactical advantage?
Your Honor, I think it's inherent in the facts of this case. You're not going to have something that shows, hey, we're holding off and doing it this way because we want to make sure her memory fades. No one's going to say that. That's not going to be documented anywhere.
Why would they have, if they were intentionally delaying to gain a tactical advantage, why would they have filed the complaint back in and put a warrant in the system back in 2013 or 2015 or whatever it was?
I believe they did.
I mean, it seems like if they were for your argument to be, well, we can infer this because why else would they have waited? They would have actually waited to indict her and indicted her right on the eve of the statute of limitations. How can we presume intentional effort to gain a tactical advantage just from what seems to be mere negligence?
I believe because you have them obtaining a warrant, and then you have them doing nothing with that warrant when they know exactly where she is, where she lives, where she works.
But by putting a warrant in the system as opposed to just issuing a summons or doing nothing, they would run the risk that anytime she gets pulled over for a traffic ticket or a tries to fly a plane or something like that, she's going to get picked up, right?
Presumably, but the issue is we don't know, we don't have any documentation. We don't know what they did when they, quote, got a warrant, Your Honor.
But isn't it your burden to show that they intentionally did this to establish it? And you're just asking us to presume that it must be that way because they did delay it, right?
Right. I'm asking you to look at retroactively what they did and find that this was done to gain an advantage. And it, in fact, did gain them an advantage because she can no longer defend against the accusations against her. In our law, we have a presumption that things should be worked out at trial in front of a jury, but you can't have a fair jury trial for Ms. Fulton under these circumstances. She's at a clear disadvantage when the state is going to say, here's these records showing she put money in her account, and what does she have to say for it? And she can't say anything to defend herself. It's clear this can't just play out at trial, that there is an advantage gained by the state because of their actions and their behaviors in this case, and that works against her. I show I have 1 minute left. Are there any other questions by any of the judges?
None from me.
Okay.
None for me.
Okay.
Thank you, Counsel. None.
Thank you, Your Honors. I appreciate your time. I'm sorry about the connection issues.
Oh, no problem. You did very well considering all things, all the technical difficulties.
Hopefully,
Yeah,
thank you.
And believe me, this is new for us as well, and we'll do our best to get through it. Okay, well, let's go back to the state for the remaining 5 minutes and 49 seconds.
Thank you, Your Honor. And I'll be brief. The only 2 points of the state that I wanted to bring up in regard to the argument by Mr. Mendoza is in regard to whether or not she remembers these kinds of things. The state would note that by her own admission in her own brief, she's done this type of work for a long time. She's worked at the same place for a long time. type of accounting, bookkeeping, that type of thing, the state would note that something as significant as being accused of stealing from one of your clients or something is not something that you easily forget. So the state would just note that.
Counsel, are you saying that the shock and I mean, yes, you remember being accused, but I think you're missing the defendant's counsel's point, which is that this will now require her to go back further than that accusation and pinpoint particular transactions. So if you'd like to respond to that point, you need to respond to the point, which is how is she expected to reach back in her memory 6 to 7 years to individualize transactions as to whether there was a reimbursement involved and what that reimbursement was for.
Again, and the state would submit that, again, these are very paper heavy. The state has gathered all of the information that was required in the state. And certainly and the state would also note that this type of evidence, specific evidence, is usually kept in logs and kept electronically and things like that. If defendant wants to then go back and look at her own records, so that's certainly
this type
very
of evidence involving a local sports booster club, or are you speaking of business cases? I think there's a distinction.
I'm sorry, Your Honor.
I think there's probably a distinction between a club volleyball booster club or a treasurer for the booster club.
This was gymnastics, not volleyball.
Excuse me. Sorry, Judge Morse. I don't want to malign the volleyball world. So gymnastics, booster club, there is some distinction, isn't there, between that and, say, a formal business where reimbursement records would be required?
And Your Honor, the point the state is trying to bring up is if there's some type of question of reimbursement where a defendant would have used her own funds to purchase something and then written a check out of the group account to then reimburse herself, that transaction would also be available on her own records, if that's her question.
Let me ask I think it's a follow-up on Judge Perkins' question, but let's assume that we agree with you that the trial court got it wrong in establishing or analyzing this as post-indictment delay, and that this is actually a case of pre-indictment delay. What is the remedy? What should we do with this case?
This case should be allowed to proceed to trial. At this point, there's been nothing to indicate that there was any kind of prejudice.
Since the defense urged it as post-indictment delay, and you didn't respond saying, no, it's pre-indictment delay and she's obliged to show prejudice, and the court applied the wrong standard, presumably, shouldn't our remedy be then to send it back and say, now she can come forward and show prejudice, and that would give her an opportunity to say, look, they're alleging this transaction, and I don't have those bank records and can't get those bank records to prove or disprove those claims. I mean, it seems like there's a lot of work in the weeds need to be done on prejudice that we should send it back to the trial court to do in the first instance rather than try and guess it ourselves here.
And Your Honor, to be frank, that's fine with the state, that we can flesh out that issue. That's fine. The state still feels that no prejudice has been shown at this point. If she's to be given an opportunity to show that prejudice, that's another question that should be resolved by the trial court. The state would agree with you on that point. The last point the state wanted to make again is just to reinforce that this type of argument creates a bad precedent in the sense that any defendant can simply delay, and then make the claim that I don't remember or some other witness doesn't remember.
Yeah, but we don't have that defendant. What we have is a state that was horribly negligent in pursuing this case below. So I'm not worried about the precedent we'll set on that regard. I understand your argument.
With that, the state has no further argument.
Okay, well, thank you, counsel, both for your argument and your patience. We appreciate it. This time we will take it under advisement and have a decision in